Yes. So, my lords, we were in G2 of 21, the final tab of volume 3. And I'd just shown my lords paragraphs 71 and 72 of the decision, where the Enlarged Board says that it understands in all the case law that it's been looking at, what the boards are actually doing is looking at whether what the skilled person with common general knowledge understands at the filing date from the applications filed as being the technical teaching of the technical teaching, and whether the technical effect is derivable from that technical teaching. And they say that if you look at it that way, you wouldn't have come to a different decision in any of the cases they've considered. And I just want to go see what they therefore must be meaning by that by going back and just looking at some examples of the cases they've considered. So could I ask you to go back to page 1338 and first pick up a few from the what they call the type 1 case law. And the first one is Johns Hopkins. And as we know, in that case, the application asserted that GDF9 was a member of the TGF beta superfamily, and those were known to have certain properties as growth differentiation factors. Now, we can see from the quote at the bottom of 1338 that in fact the application asserted that certain properties of certain of those growth differentiation properties would be possessed by GDF9. See that at the bottom of the page. And going over the page, we then see what the problem was for the applicant in that case, which they've highlighted. And what's being said here is that because there was no structural similarity with known TGF beta family members, and there was no functional characterization in the application, doesn't sufficiently identify the fact as a member of the family, i.e. not enough evidence to make it at least plausible that the solution was found to the problem which was purportedly solved. And as we've seen, what the Enlarged Board have said in 71, 72 is that in this passage that they've quoted, the TBA is focusing on the technical teaching of the application and considering whether the technical effect is derivable, and they've reached the right decision. And so we can see what the EBA means by focusing on the technical teaching and considering whether the technical effect is derivable. It's not saying that is, that the technical teaching is, if you just say, I've got a new compound and I predict it will have these properties, that is technical teaching from which the technical effect can be derivable. Because if that's what the EBA had in mind, then they would not have said that applying that approach, the board in Johns Hopkins had come to the right decision. So they're saying that the TBA is right to look beyond mere assertion and to look what the actual technical teaching is as a technical matter, not just a matter of assertion. And whether it's possible to derive the technical effect from that which is actually taught as a technical matter. And in Johns Hopkins, they say that's what the board was doing, and it got the right answer. Similarly, if we look down to the bottom of the page, the next one they deal with in bold is T787 of 14. And in this case, the claims were product for use claims in EPC 2000 format, and they related to use of a compound in patients who had the characteristics that we see in the first bold quote, i.e. pre-immunised at least 6 months previously and with 1 year of birth with that particular conjugate. And then we see what the technical board says between the bold quotes. You have to assess inventive step at the effective date of the patent, base information together in the patent together with the CGK, and then the verification of whether that solves the problem has to be based on data in the application in order to avoid that it's based on knowledge available after the effective date, etc. It has already to be credible. And the board concludes from the above analysis that the problem to be solved can't be defined as put forward by the appellant, because one couldn't conclude that the evidence in the document was in fact in the group of patients that were identified in the claim. And so what the TBA is doing in this case, again, is looking for a credible disclosure in the patent to the effect the problem has been solved and is not finding one. And what the EBA sees that as being is look at the technical teaching and consider whether the technical effect is derivable from that technical teaching. So that's what the board's been doing, and it's come to the right conclusion. Similarly, the next one down, T488 of 16, which of course is dasatinib, we've looked at that, and we see the highlighted section. And I think that is from a passage that Mr. Turner took you to. And so, again, what the EBA is doing here is highlighting that what the TBA was doing was addressing the technical teaching of the application to the skilled person, considering whether the alleged beneficial property of dasatinib was derivable from that technical teaching. And they say without any data, that couldn't be done in the absence of correlation between structural features and function. So again, this is what the test that the EBA is putting forward. It is not one where it's satisfied by mere assertion, but they're looking for actual technical teaching from which one would derive the technical effect. If we then go to some examples from the type 2 line of case law, so if you go on to page 1343, you'll see that this is where they consider decisions referred to as type 2 case law. And I'm going to pick out ones where they've highlighted. So the first one is page 1344, halfway down, T1642 of 07. And one can see just before the bold quote that there was they say, the board says, the fact that disclosure in a patent application is merely theoretical and not supported by experimental data is in itself no bar to patentability. And of course that's right, and that's consistent with Warner-Lambert. And then they go on to quote, the bit that they highlight is the bit where the board is discussing the Johns Hopkins. And the TBA is saying here, in Johns Hopkins, a dichotomy arose between the disclosure in the patent application, which didn't contain the either structural or functional characterization of GDF9, and on the other hand, the teaching in the post-published document that GDF9 was indeed a growth differentiation factor. And then we see that the TBA goes on to distinguish the case before it from Johns Hopkins. So again, we say we see here, the EBA is saying TBA is correctly focusing on the technical teaching and whether the effect is derivable. But it's not saying that mere assertion is enough. What it's saying is that in that particular case, the theoretical disclosure was sufficient, and drawing the contrast with Johns Hopkins where the facts were different. Then we go to T1677 of 11, top of the next page. And this is the one where the claim was to a essentially pure sodium salt of the minus enantiomer of omeprazole. And we see from the quote, they say, look, the facts of the present case differ substantially from Johns Hopkins. In the present case, the structure of the claimed sodium salt of minus omeprazole is fully consistent with that of the known class of gastric acid secretion inhibitors. In fact, the prior art in that case was included omeprazole itself as a gastric acid secretion inhibitor. And that's why it differs from T1329 of 04. And in the patent in suit, this is the highlighted bit, a consistent and verifiable disclosure is provided, the essential elements of a specific structure and corresponding therapeutic benefit. So, again, what they're saying here is, well, the TBA thought in that case, because of the structural analogy between omeprazole and its enantiomer, that was enough to conclude that minus omeprazole would be, was plausibly effective. And again, the EBA is saying they're doing the right thing here. They're looking at the technical teaching and considering whether the technical effect is derivable from it. And in that case, it was. And then the final one, I think, is T20520, bottom of the next page, 1346. And This is actually, I think, about sufficiency of a product for use claim, but in any event, let's see what the board was saying. Here, what the enlarged board is highlighting in the decision is the fact that the board in this case considered the statement in the application that the treatment of respiratory disorders, particularly asthma and COPD, with aclidinium is most effective upon administration by inhalation of about 400 milligrams, as being a specific technical teaching. And as they say over the page, it's a specific technical contribution which goes beyond some insufficient verbal statement. So again, what the EBA says is what the board is doing here is focusing on the technical teaching and considering whether the technical effect is derivable from it, and they've done the right thing and come to the right conclusion. Now, so what the EBA is saying by looking at these various TBA cases and saying what it is in 71 and 72, it's not saying just look at what's claimed. It's not saying just look at what's claimed and what assertions are made about it, because if it meant that, it would have said Johns Hopkins and dasatinib were wrongly decided. It means look at what's actually taught as a technical matter rather than words on a page. What is the technical content of the disclosure, and can you derive the technical effect from that disclosure? So the EBA in 71 and 72 prefers to avoid the language of plausibility, but that doesn't mean it's rejecting the substantive content of the concept. And we say, on the contrary, it is affirming that by saying, look at what the technical teaching is and consider whether the relevant technical effect is derivable from that teaching from the application by the skilled person with the common general knowledge. And if a technical teaching is such that the technical effect is not made credible, then it can't be derivable. So, my Lord, that's when it looks at the TBA case law. If I can then ask my Lords to go forward to 1355, there's a section on the national legal framework and jurisprudence with respect to inventive step. And they consider decisions in Switzerland, Germany, France, the Netherlands, and this jurisdiction. And I was just going to draw my Lord's attention to what it says about the UK on 1359. In 84, it starts by citing the decision under appeal in this case as providing a summary of the case law on plausibility, both before the national courts and the boards of appeals. And the approach, they talk about, mention Warner-Lambert and Fibrogen, so the approach taken in Warner-Lambert has essentially been confirmed in the Court of Appeal decisions in Illumina, Fibrogen, etc. And then it goes on to discuss this further in the following paragraph. And then we get to paragraph 86, where they say, having looked at all the various EPC contracting states, none of them provide for explicit patentability requirement. What the referring decision discusses and addresses what is referred to in questions 2 and 3 under the term plausibility. And that's right, of course, because as your assumption made clear in Warner-Lambert, plausibility is not itself the statutory requirement, is a criterion by which one addresses questions of whether the statutory requirements are met. And then in 87, the Enlarged Board says that it recognises that the courts of the contracting states, when considering inventive step and post-published evidence, ponder on the technical teaching of the claim subject matter that the person skilled in the art with the common general knowledge in mind understands from the patent application. So there's no suggestion here that it's regarding the decision of the national courts, and in particular the decision in this case, as being inconsistent with what it is putting forward as being the approach, which is look at the technical teaching of the patent application. On the contrary, they are aligning its understanding of the national decision, including this one, with its own approach. Then we come to concluding considerations, and they start by dealing with pre-evaluation of evidence. And then at 92 on page 1362, they make the point they've made before, that plausibility is not a distinctive legal concept or specific requirement under Articles 56 or 83, but what they refer to as a generic catchword used by various courts and users. And then in 93, they say the relevant standard for an inventive step concerns the question of what the skilled person with the common general knowledge in mind would understand at the filing date from the applications originally filed as the technical teaching of the claimed invention. And that reflects what they said in paragraph 71. And then the second sentence, the technical effect relied on, even at a later stage, needs to be encompassed by that technical teaching and embody the same invention, because such an effect doesn't change the nature of the claimed invention. And, my lords, that obviously has to be read in the light of what they've said in 72, where they've talked about the technical effect needs to be derivable from the technical teaching. And what they also have in mind here, we would submit, is that they're bearing in mind the cases in which it's necessary to reformulate the technical problem. Because the way in which this is expressed is redolent of the way in which the case law of the Boards of Appeal expresses questions of whether or not it's possible to reformulate the technical problem. You're not allowed to change the nature of the invention in doing so. I mean, if it helps, perhaps I can just hand up an extract from the case law book, which I think shows this. And this is the 10th edition of the EPO's case law book, and we've given you the section 4.4 on reformulation of the technical problem. And the passage I really wanted to draw your attention to is, you'll see 4.4.2 is when you have to reformulate the subjective, in other words, that appears in the document, into an objective technical problem. And we see at the last paragraph of that section, so on page 214 of the extract, second full paragraph, as a matter of principle, any effect provided by the invention may be used as a basis for reformulating the technical problem, as long as that effect is derivable from the applications filed. And we see at the end of the paragraph, in relation to new effects, it's permissible to change the nature of the invention. So this is the language they're using in these paragraphs is reflective of the kind of language they use in the context of where it's necessary to reformulate the technical problem, which, of course, as I've said, is not an issue which arises in this case. Similarly, 94 of the decision, you may rely on the technical effect or inventive step of the skilled person having the common general knowledge in mind and based on the application originally filed will consider said effect as being encompassed by the technical teaching and embodied by the same originally disclosed invention. And that almost reflects paragraph 2 of the order. If you note the order on the next page, they've expressed it slightly differently. Where they've said it has to be, you have to derive such effect. That's the fourth line of the order. So they're using derive and consider equivalently. So, my lords, what we say about this is that the test which the Enlarged Board is putting forward for reliance on post-published evidence in the context of inventive step is, what is the technical teaching? Is it possible to derive the technical effect? Is the technical effect derivable from that technical teaching? And that is focusing on a proper technical teaching, not just mere statements. And if a technical effect is not credible, it's hard to see how it can possibly be derivable. And what they're talking about at the ends of paragraph 93 and 94 is they're considering the cases where one has to worry about whether this is a technical effect. When they're reformulating the invention, one has to consider whether the technical effect now relied on is one which was the same invention and to be found in the original technical teaching. And then, as we see, they recognise in 95, we looked at that earlier a little bit, that the criteria are rather abstract and the answers will depend on the circumstances and the technical field in question. But, my lord, we say that the EBA decision doesn't mean one no longer has to consider whether the disclosure of the application with regards to an alleged technical effect is credible. On the contrary, we say they emphasise the need to focus on the technical teaching, not just the words on the page, and consider whether it could be, technical effect can be derived from that technical teaching. And in the technical field of compounds alleged to have a biological property of therapeutic application, that will depend, as we've seen from the various cases that they refer to, on matters such as whether there's any functional characterization of the compound, whether structural comparisons with known compounds allows one to attribute a function, and the state of the common general knowledge. And that may, as I say, that obviously it may depend on the technical field. So, my lord, then I said I would go back to the question, the paragraphs on sufficiency, and that starts at 73, page 1348. And you can see that in 73, they say we don't need to answer, provide an answer on sufficiency of disclosure in Article 83, but we accept that it's appropriate to do a comparative analysis. And they then point out that you have to consider sufficiency and inventive step separately, and they refer to the case law on medical use claims, and then they make the point that at the top of page 1349, the technical effect, for example, a second medical use claim is usually a therapeutic effect, the feature of the claim. So the issue of whether it's been shown the effect is achieved is a question of sufficiency of disclosure, and then it's necessary. It's necessary that the patent, the data it's filing, renders it credible that the known therapeutic agent is suitable for the claimed therapeutic application. And then they go on, because the point just pausing on there is, of course, when you've got a technical effect or technical property expressed in the claim, then that's always going to be the target when you're considering the question of sufficiency. And we don't have the issue that arises in inventive step analysis of potentially reformulating the technical problem, because your target is defined by the claim. That's what you're always going to have to satisfy: sufficiency, credibility for the effect that's defined in the claim. You can't get around that, or you can't end up in a situation where you're asking a different question because the prior art is different. So they then go on to consider the case law Salk and various others over a number of pages, and then at 1355 they say that the scope of the decisions above, the scope of reliance on post-published evidence is much narrower on sufficiency of disclosure compared to the situation under inventive step. And of course, one reason for that, my lord, is the one I've just given, which is that in the context of inventive step, as they, indeed the referring board is saying, there's always, the issue will often arise more because you've got the question, possibility of reformulating the technical problem. And it may well be that you want to try and rely on post-published evidence in relation to a reformulated technical problem. In relation to Article 83, you've always, as I've just been saying, got your fixed target. And so the scope for this, the application of this, is going to be narrower. Then they go on to say that in order to meet the requirement for sufficiency, the proof of a claimed therapeutic effect has to be provided in the application as filed, in particular if in the absence of experimental data it wouldn't be credible that the therapeutic effect is achieved. You can't remedy that by, lack of that respect can't be remedied by post-published evidence. And So here, because obviously the case law that they've just cited is all consistent, they haven't felt the need to find a reformulated form of words, and indeed, of course, they haven't had to because they've not been asked questions about sufficiency, and they've made that clear that they're not having to answer questions about sufficiency. In order to answer the question on inventive step, what they've chosen to do is to avoid the use of the word plausibility, as I've explained, but nevertheless show us that the substance of the test of plausibility is still very much alive, because that is what the effect, in fact, that the TBA has been doing in all these cases. It's been looking at the technical teaching and consider whether you can derive the technical effect from it. So, my lords, the other thing is what they're not saying here is that if the same technical effect is being relied on, one gets a different outcome depending on whether one's considering sufficiency or inventive step. They certainly do not say that. So, my lord, in coming back to this case, as I've said, the same technical effect is being relied on by BMS, both in respect of sufficiency and inventive step, and in respect of all the claims in issue. And it's impossible, we say, to see how they could pass the test on one limb if they lose on another. We say that the law remains that set out in Warner Lambert and the various Court of Appeal authorities that Dr. Turner's taken you to. But no different result would emerge from applying what the EBA says in this case. Not surprisingly, because they don't disapprove the approach being taken in the UK, nor the cases on which it's based, such as Johns Hopkins and the like. And the technical effect, using the language of the EBA, applying it to this case, the technical effect that BMS need to contend for, both for Claim 1 and Claim 7, is the nanomolar Ki. And we say such a technical effect cannot be derived from the technical teaching of the application. There is no technical teaching in the application about the activity of apixaban for the same reasons as those given by the judge. So, page 170 does not provide any technical teaching about the activity of apixaban for the reasons the judge gave in the section of his judgment on that, still less that it had a nanomolar Ki. One cannot draw any inference about the activity of apixaban from the effect that 3 grams was synthesized for the reasons that the judge has explained and we were looking at earlier, still less that it had a nanomolar Ki. Nothing emerges from the frequency of use analysis, and it's not possible to predict activity from the structure of apixaban. Indeed, the binding of apixaban to factor 10A was unexpected and hard to rationalize even in retrospect. And so all that leaves is the bare assertion that all the compounds of the invention of the application, all the 10 to the 25 or however many it is compounds, were factor 10A inhibitors and useful to treat thromboembolic disorders. Those are points that BMS abandoned at trial. They did not rely on them, and they cannot be, we say, a technical teaching of the type which is envisaged by the Enlarged Board, because if those sorts of bald statements were to be regarded as technical teaching from which you can derive a technical effect, Johns Hopkins would have been decided the other way, and the Enlarged Board would have said that it should have been. So, my lord, unless I can help you further, those are our submissions in response to the appeal, and I think Dr. Turner was going to raise with you how we proceed now.
Very good. Thank you.
My lord, the suggestion, having discussed with Mr. Alexander, the suggestion was I now do the respondent's notice and then he'd reply on both.
That would make sense.
If that's convenient. My lord, it is a relatively short point now that we've looked at the authorities. Our position is that a claim to products per se or a product per se is only justifiable where the product per se is inventive or where it could not be made without invention. And only in those circumstances can the technical contribution be said to be the molecule itself. And we submit that where the inventive contribution is limited to the recognition that an organic molecule has an inventive use, that use should be a limitation of the claim. Now, we acknowledge this has not fallen for judicial determination before, but we say this reasoning is an inevitable consequence of the development of the law in this area, and also aligns with the availability of use claims, which have now been around for a considerable period, since 2004. We also say the context is important. This is not a case where it's contended the structure of apixaban is not obvious from the prior art, or that the prior art did not enable its synthesis. That's an important consideration in this case. The cases which give rise to this are, of course, Biogen, Exxon, Warner Lambert, who have repeatedly emphasized that a patent claim should reflect the technical contribution of the patentee. And we also have the jurisprudence from Agrevo that the provision of organic molecules per se does not represent an inventive step. Perhaps not. That's maybe not in all cases, but certainly in Agrevo and in this case. The need to grant product claims in these circumstances has also has waned over the years and fallen away altogether with the introduction of the EPC 2000 claims. Just remind my lords, EPC 2000 claims are claims like Claim 7 in this case to a compound, say compound X, for the treatment of a condition Y. So it has two elements to it. And they are only infringed if you commit an act relating to treatment Y. They are the proper claims when your technical contribution relates to the recognition that the compound is useful for that purpose. A product per se claim, on the other hand, that's just to compound X, without a use limitation written into the claim, is infringed by the use of that compound for other uses. And that's been emphasized recently in Fibrogen as paragraph 57, authority was required. And so it could cover uses which owe nothing to the inventive activity of the patentee. Now, there is some historical background to this whole area, which my Lord Justice Arnold will be familiar with. But, prior to the 1977 Act, it was not permissible to have claims to a medical use because it was not interpreted as being a manner of manufacture. That was a belief among practitioners. And so to protect the discovery that a compound identified in a Clerkenwell sewer is useful as an antibiotic, it was necessary to claim the product per se. This was, in many ways, not entirely satisfactory. It's often said the reason for outlawing these use claims was because of the need to protect medical practitioners from patent actions. But if one goes back, certainly in the cases in the UK, it's not entirely clear that was originally the position. This first was considered by the Court of Appeal in the Upjohn Company in 1977, RPC 94. We can provide copies if it would be helpful. And that it's decided that it's just not a use, is just not a manner of manufacture. And that's how these cases were decided. That was shortly before the 77 Act. Now, when the Act came in, there were then introduced an exclusion for medical uses, which is under Section 2.4 of the Act. And this reflected a provision in the European Patent Convention. But there was an exception, and it was permissible to have claims to a medical use of a known compound under Section 2.6 of the Act. So this was interpreted as being the fact that you're entitled to a claim to a first medical use, but not subsequent medical uses. But this created problems because there are many examples where therapeutic compounds have been discovered to have more than one effect on different diseases. And there are profound reasons why that is the case. They can be quite unrelated conditions. And there was a need also to innovate or improve therapies of known treatments. And so we developed in the UK, and it was developed at the European Patent Office, this rather ornate jurisprudence with regard to the grant of what are called Swiss form claims, or second medical use claims. And they themselves have caused certain problems, and one can see those when one looks at the decision on infringement in the Supreme Court in Warner Lambert. These problems have all now been swept away, at least most of them have been swept away. By the...
I mean, come on, we haven't really confronted the problems with EPC 2000 claims yet. I mean, yes, some
of them have been swept away.
Some of them are dealt with.
And we now
remain.
So we now have EPC 2000 claims, and that's what the Claim 7 in this case is. So it's now permissible in the medical field to have a claim to a compound limited by therapeutic use. So we're in a very different position to where we were 40 years ago, when it wasn't possible to have therapeutic use claims at all. So one can argue that the policy reasons, if ever there were policy reasons, for permitting bending over backwards to permit product per se claims has fallen away. So we ask rhetorically, why in a case such as this should a patentee who has described a compound from a known class, we do emphasize that, useful for a particular purpose, why should they be entitled to a monopoly which covers that molecule for entirely unrelated uses? So in the application as filed, describing billions of molecules on the basis they were useful as factor Xa inhibitors. Somebody else might want to use them as for treating Alzheimer's or making an insulator.
But sorry, why are you suggesting that this is a problem unique to chemical compounds? Surely it applies to any product claim. Well, suppose I invent a new thermocouple, and
Yes.
the purpose for which I'm intending to do so is to measure temperature. But subsequently, it is appreciated that this thermocouple can be used for measuring, let us say, oxygen concentration in the atmosphere by some route.
Yes.
My monopoly over the new thermocouple that I got because I invented it for temperature measurement will cover the new use.
Indeed, and then one would ask the question...
Can I be clear?
Yeah.
Is it your submission, the principle you are expounding, which you say this court should accept, would apply to all product claims?
It would apply to product claims in circumstances where it is accepted that the product per se is not invented. So if your thermocouple, that's the limitation that we rely on. It's the agrevo limitation, which is common ground in this case. So if your thermocouple was obvious as a structure, then you would, my lord would, in the example, would need to be limited to the specific use. But if the structure of the thermocouple was innovative per se, then of course you'd be entitled to a monopoly covering all uses. And it's the same, a very similar position was arrived at in generics and Lundbeck. My lord, in that case, of course, the compound could be envisaged, that was the enantiomer, could be envisaged, but nobody knew how to make it.
It was more than envisaged. Everybody knew perfectly well it was there. The question was how to get it.
How to get it. And there wasn't a method of manufacture. And it was held that the technical contribution was the molecule per se, and consequently, compound per se claims were valid in that case.
But what's the logic? If it is justifiable purely because you find one way to make a molecule which it has not been possible previously to synthesize, why should you get a monopoly on all ways of making it?
Yeah.
Why is the logic any different?
Right. Well, the technical, of course, what the Court of Appeal did, and subsequently the House of Lords, they said that you have to distinguish the inventive contribution from the technical contribution, and the technical contribution in that case was the molecule per se.
But it wasn't. The technical contribution was providing a way of making it, because the molecule per se was known.
I think it might be worth having a look at. I think they drew a distinction between the inventive contribution and the technical contribution. That's tab 12 of the Joint Authorities Bundle. And I think it's really on page 299 of the bundle. And if I just invite my lords to read 29 and 30. So the invention's technical contribution is the end of the paragraph to the art is concerned with the evaluation of its inventive concept, how far it's carried the state of the art. The inventive concept and the technical contribution may command equal respect, but that will not always be the case. And then one picks it up at the end of 34. The technical contribution was, as the Court of Appeal recognised, the isolated enantiomer, now called escitalopram. But it would, on this hypothesis, prove no more useful than the unresolved racemic citalopram. But what the court was saying is, look, what the invention has, the art has been given is the molecule for the first time. For the first time, you could pick up the isolated enantiomer, you could hold it, you could use it, and you could use it for any purpose. And so consequently, the technical contribution extended to the molecule per se, because there weren't obvious ways of making it. It was at the priority date, it was the only way of making it. And so in this case, once you have the concession that the molecule per se is obvious, you're necessarily beaten back to the position, as would have been the position in Agrevo, that the technical contribution is limited to the purpose.
When you say the molecule per se is obvious,
yes.
I mean not just you can write out a chemical formula,
yes,
but you know how to make it.
Yes, there's never an issue that you know how to synthesize these compounds. And this was, part of our case, so that case wanted to be made out of it.
I'm still struggling to understand how this works on the facts of that case. Because in that case, the prior art was the racemate. That is
yes.
to say, a mixture of the two mirror images.
Yes.
Forms of the compounds.
Yes.
So the one that you wanted was present already. Its existence was known already. It was known already that in principle it would be desirable to separate out the two enantiomers.
Yes.
The question was how to do it.
Yes.
So the fact that it was not merely that it was known to exist, it had actually been made before. But it wasn't useful to you because it was inextricably mixed up with the other enantiomer.
Yes. I mean, my lord, there was quite a lot of evidence about whether it's right to conceive of a racemate as a mixture of enantiomers, and whether the skilled person would look at it that way. But subject to that qualification, my lord is absolutely right, yes. But the question is, you needed, for good reasons, for pharmaceutical purposes, you needed to have the enantiomer on its own. And my lord will recall it's actually advantageous. The other material isn't just dead weight; it's actually advantageous to have it on its own. And until the patentee had made the invention, you simply couldn't have it in isolated form. So you're entitled to a claim, and it does equiparate with the technical contribution. It represents the technical contribution. And the issue in Lundbeck was, should you be limited to your particular synthetic method, because you might be covering synthetic methods that emerge in the future. And that was the distinction between inventive contribution and technical contribution. But here, so the argument, there was an argument, and of course, Mr. Justice Kitchen, I think, still bridles on this case, but there was an argument that it should, in the light of Biogen, it should have been impermissible as a claim. But that's to some extent getting into the facts. The principle is consistent with the principle that your claim must be limited to your technical contribution. And of course, in many other cases, my lord has given the thermocouple example. There may be sort of graphene or non-obvious organic chemicals. None of this would apply. And in many cases, your technical contribution will be as broad as the product per se. We don't in any way say this is a universal principle that will apply to all cases. It applies where the structure is. In this case, apixaban was just a member of a known class, and no positive case has been advanced that its structure is inventive or that it was obvious how to make it.
Was not obvious how to make it.
Sorry,
was not obvious how to make it.
Not obvious, yes. And it's somewhat ironic in this case that my learned friend points to claim 1, we'll see what he says in reply, but points to claim 1 and says, different considerations arise because I'm claiming the product per se. And he positively relies on that to say that my lords do not have to show deference to the plausibility of the effect.
Yes, so in other words, you're saying it's paradoxical.
It's paradoxical.
That it should be argued that a lower threshold should be applied to a broader claim.
Yes.
There should be a higher threshold of patentability for a broader claim, not a lower one.
Yeah, indeed. That's exactly the point. And, my lord, it's a very, very, conceptually, it's a very simple argument. If the technical contribution is limited to the use of that compound according to well-established principles, the claim should be limited to the technical contribution. And it's no more difficult than that. Now, Mr.
Can I
Justice...
ask you?
Yes, sorry. Yeah.
If apixaban was known in the sense that it's listed in the literature and it's known how to make it
As prior art.
as prior art,
Yeah.
why is a claim to the compound novel?
It wouldn't be. You'd have to be limited by use then. So you'd have to have something like claim 7. So let's assume that apixaban was in a textbook as a known intermediate molecule or a known molecule used in synthesis, and it was known how to make it. And you discovered, and it was indeed inventive, that it had a particular pharmacological effect, then you'd have a claim to the compound per se for use in that pharmacological.
But that'd be like claim 7. But I thought you said apixaban was known.
It was.
Only as a member of a class.
Only as a member of a class, yeah. So we don't get home on novelty for particular technical novelty reasons, which my Lord Justice Arnold made reference to earlier in the case. So it's not an individualised disclosure within the class. So had it been listed as one of 20 molecules, we'd have said there it is, it's an individualised disclosure.
So if you disclose a class which in fact includes apixaban, that's
Yes.
not a disclosure of apixaban.
Yes, if you include, if you have a broad class with apixaban as a member, and it's not an individualised disclosure, and of course one can have argument about whether it is or isn't, and then you have bare novelty. So, and that's the Dr. Reddy's case, which we've seen references to. And that's in that context, Lord Justice Jacob was saying you can, hide a book in the Bodleian Library. That was the thinking behind that. So if you have a broad class, it isn't a disclosure of all the individualised members of the class. And there's an inquiry as to whether in any particular case it is or isn't. But it wasn't argued in this case that apixaban lacked novelty from from the class. But but the structure per se is obvious for the reasons given in Agrevo. You know, that reasoning, any chemical molecule is obvious.
It had been disclosed as a member of a class, not individual.
Yes. Does that
No, that makes a lot of sense. And as you say, there's room for debate about on particular facts whether there has been disclosure individually.
Yes.
It would depend on the size of the class and possibly other factors.
Indeed, quite so. Mr. Justice Meade was concerned that he declined to decide this point and was concerned that it may have far-reaching effects and that he hadn't been given enough assistance. The position is there is no authority on this point. Perhaps these concessions are not made often, but it does arise in this case. And of course, we say two things. First of all, we're not saying that product claims are never valid, product per se claims, and I've addressed my lords on that. It's all to do with the closeness of the prior art and absence of arguments as to whether the product per se is inventive. Second, we'd say, look, it's extremely rare these days to see patents without use claims. And one can look at Idenics, we can look at this case, and they may have product per se claims, but they'll also have use claims, because use claims have been permissible since 2004. So typical cases...
My memory may be at fault, but I didn't think there was a use claim in Idenics. I mean, that's what's slightly odd about that case. It was a compound claim that was treated as a use claim.
No,
were there use claims as well?
Yeah, there were.
I fully accept that's common, but I just couldn't remember.
No, that's quite right, because the focus was, because of the concession, they have to be treated the same. We never really looked at them again. If you go to tab 20, I think we can take it from tab 20.
Yeah.
Long bundle of comments. And I think I showed my lords the claims on page 733. And claim 1 was the compound, so it was the bottom of 732 was the compound per se claim, and then we looked at claim 6, the use of treating flaviviridae infection, and then you had claim 7, the use of when the virus is hepatitis C. And my lord, we see these use claims a lot, and of course 2004 is quite a way ago. Where the pre-2004 patents, of course, could have Swiss form claims, but my lord, it's a very long time since. Other people may have different experience, but it's a very long time since I've just seen a Marcouche type pharma patent with just product per se claims. We've looked at for authority on this point in other jurisdictions. So my instructing solicitors have made inquiries of Germany, the Netherlands, and France, and we understand there's no cases on this point either way. The European Patent Office, we don't believe there's anything on this point either. Of course, the European Patent Office don't have to worry about the infringement consequences in quite the same way that national courts do. But the fact that this hasn't been argued before doesn't make it a bad point. and we do say it, to some extent, it arises in this case precisely because both below and here, the patentee has said there's a difference between the use claims and the product claims. And that's what's brought it into sharp relief. It was that below it was argued that any use would do, any use in the specification, using it as a standard would be enough to make that patent valid.
But that's no longer maintained.
It's no longer maintained, but now we're seeing a slightly different, reorientated argument that different considerations of plausibility arise with product per se claims. So in both below and today, we see that a different approach has been taken. So, my lord, we say, look, if the product per se is obvious, if there's no technical contribution of the product per se, then it's straightforward Agrevo obviousness. And same extends beyond the technical contribution. That gives rise to Biogen insufficiency. And we say it's just a natural consequence of the way the cases have developed. And the fact that it hasn't arisen before is just reflected partly by the fact that litigants haven't previously chosen to draw a distinction between product per se claims and use claims. And so if you get a case like Idenix where it's accepted, you've got to show everything as if it were a use claim. The point immediately falls away.
Sure, yeah. That's certainly what happened in that case.
Yeah. My Lord, unless I can assist further.
All right, thank you. Mr. Alexander, any reply?
My Lord, it's perhaps convenient just to deal with that point first of all, before going to the main part of the appeal. That there are two fundamental problems with it. The first is the starting point. If I could just invite my Lord to look at paragraph 10.3 of the judgment below at tab 8, page 96. It's quite wrong to say that this isn't a case about an inventive molecule. There is no classical obviousness case advanced at all over 131 or any other document. And just by way of further explanation for my Lord Lord Justice Nugee's points, the reason that a individuated or sub-individuated class of pharmaceuticals can be both novel and inventive over a previous class that was much broader is because part of the way that chemistry works is by people inventively working out which pharmaceuticals to make out of a given class that may be enormously broad. You may have, because of the way that chemical formulae are described, a very broad formula which potentially encompasses millions of compounds, and pharmaceutical research operates by people saying, well, okay, I'm going to identify either this little area to work in or this specific area to work in out of this very large class. It's never been the law that because a very broad class may have previously been disclosed, a more specific identification of a pharmaceutical within that class is either obvious to make or lacks novelty. And that's because that's the nature of invention in this field, one of the areas in which invention...
So selecting from a very large number of potential compounds, an actual one to make, is itself both novel and not obvious?
Yes. I mean, there can be situations in which a patentee, which someone challenging a patent says, oh, well, because of the directions given with respect to that very broad class in earlier prior art, in fact, it was obvious to identify that particular member of the class and therefore make that particular
This
member
can't
or
be
members.
right. I'm sorry, this can't be right. If selecting from a class was enough to make it inventive, we wouldn't be here arguing about plausibility.
No, but my point. But that was not my point. My point was a somewhat different one, which is that the fundamental point that my learned friend was appearing to make, namely that this wasn't an invention fundamentally, and that what he appeared to be saying was that there was some fundamental obviousness attack on the product, was not right. There was, as the judge said, the claimants do not say that it was positively obvious to get to apixaban specifically from 131. That's the point. So anyway, the starting point of the argument is in our respectful submission wrong. But to suggest that there is no authority touching on this point in the United Kingdom is equally wrong. There is authority touching on this point in the United Kingdom, and it goes the other way. The Lambert case that has just been referred to is in our submission clear authority that the proposition which is contended for under the respondent's notice is actually wrong.
So the enantiomer one?
Yes, that's the enantiomer one. And the explanation for that is given in the judgment of Lord Justice Jacob in the Court of Appeal at tab 10 of the bundle at 266 of the Joint Authorities 1, page 266. The policy argument that is advanced by my learned friend for why this court should adopt what I think is accepted to be a revolutionary principle is that it therefore gives a patentee more than they've invented, in inverted commas. Well, that is not accepted, because if a patentee has invented, in the sense of individuating, a new molecule for the first time, it's not more than they've invented in any sense. But even were it so, that's a matter that's actually catered for under the law. Lord Justice Jacobs says in paragraph 54, any product claim is apt to give the patentee more than he has invented, and in two ways. First, such a claim will have the effect of covering all ways of making product, including ways where the inventive and quite different from the patentee's route. Secondly, it will give him a monopoly over all uses of the patent compound, including uses he's never thought of. And then he goes on to elaborate at that point and considers the converse of it. And so this explanation, which is essentially one that was accepted by all throughout in relation to that enantiomer case, applies with equal effect in this case. The same proposition was essentially accepted by Lord Hoffman, and the same was said in the House of Lords. So in our respectful submission, the English case law is absolutely clear on this point. My learned friend says that there is no European case law on this, and it is certainly true that no one may have even thought to argue a point of this revolutionary nature before the EPO. We have actually found a case which, albeit in a slightly different way, suggests that it is completely wrong in the EPO, and that's a case T042421. And we haven't put it in the bundles, we only found it recently, but I've given it to my learned friend. Have we got copies of it? It will be. No, I'm told I've got copies. Perhaps I can just go on.
Yeah.
There was a challenge there to sufficiency of the patent, and the argument was, well, the patent, which was a product patent, was insufficient because it was essentially a product patent, and it was covering more than only the first medical indication. That is addressed in paragraph 32 of the judgment onwards to paragraph 40, and the EPO, albeit dealing with the argument framed in a slightly different way, rejects it there. At paragraph 40, there's no requirement from the EPC where a patent would have to show that the compound is suitable to each and every disease in order for a first medical use to be sufficiently disclosed. Instead, it's sufficient to show that the compound is suitable for at least one particular medical use, as is the case in the patent in issue. So it is not quite right to say, as my learned friend says, that there is no authority. Such authority as there is suggests that the proposition is wrong. In relation to the position in other member states, again, we are not surprised that it has not been possible to find any support for the proposition from the jurisprudence of any other member states, because we suspect that this proposition, which is rightly described by the judge as being a little radical argument with far-reaching effects, is probably not one that's even been argued, because, and essentially the reasons given by my Lord Justice Arnold, which is that it's been accepted almost since the beginning of patent time, that once one has identified a proper invention with respect to a product, one's entitled to a patent in relation to that product. The fact that what has happened in recent years is that the development of second medical use claims, which acknowledge a different issue, namely the fact that there can be invention in discovering a second medical use in relation to an old, obvious product, doesn't mean that a patentee is not entitled to a claim in respect of the product.
Well, it does go a little bit further than that, because there's also, as has been pointed out, quite a lot of case law with first medical uses.
Oh, indeed. But my point is that the general proposition that my Lord articulated is right, and that the argument which we detect being put against us on this is, well, the fact that there are second medical use claims now as part of an established jurisprudence, whether under Swiss form or under EPC 2000, means that one can sweep away the need for product patent protection. It doesn't do justice to the reason why that line of authority and that line of development to the statutory scheme was itself introduced. So we respectfully submit that there is no substance at all in the respondent's notice. Can I then go back to deal with the points made, and I'll try and keep this rather short and deal with them in substantially the order in which they were put forward. The first point is going back to the basic proposition on law and the standard which this court should be applying to evaluation of the patent in issue. In our submission, to use the words of Warner-Lambert in paragraph 37, if one applies the approach of Warner-Lambert, the law is that the claimed therapeutic effect may well be rendered plausible by a specification showing that something was worth trying for a reason. That is not, as it has been said, a particularly demanding standard. And one reason is that the patentee here has claimed efficacy in disclosed material from which, I'll come back to that, it can reasonably be inferred that efficacy has been shown. Putting it another way, in terms of the Warner-Lambert test, assuming that that applies, on the facts as found by the judge, and what could reasonably be inferred, that constitutes taking, again to use the language of Warner-Lambert in paragraph 37, something that would cause the skilled person to think there was a reasonable prospect that the assertion would prove to be true. Now, the fault lines have been actually more clearly identified in the manner in which Mr. Tappin has developed the argument in relation to the contents of the specification. Because what is really submitted now is that unless it is possible to infer the relevant technical characteristic uniquely and unambiguously from the specification, that doesn't satisfy the test in Warner-Lambert insofar as the test in Warner-Lambert is the right test to apply. In that what is said is that if, for example, there is more than one thing that a skilled person could reasonably infer from the specification as to the efficacy of the product in question, that is not enough, precisely because there's more than one thing that can be inferred.
Well,
from.
with respect, I don't think that is the argument at all. The argument is not that a skilled person could reasonably infer more than one thing from the specification. The argument is that there is no basis for an implicit disclosure because there's more than one explanation for the explicit disclosure. That's a different argument altogether.
Yes, my lord is right to reformulate it in that way, but those 2 points are related one to the other. Because if one is thinking about what a skilled person would be reasonably entitled to infer, that must be based on what reasons the skilled person would have, objective reasons that a skilled person would have for making the inference. So the points are not completely separable. If there are in fact reasons from which a skilled person could infer a given proposition, then in our respectful submission, the fact that there are 2 alternative explanations available from which the skilled person would infer different things on the hypothesis of those 2 explanations does not mean that there is nothing in the specification from which the relevant material could be inferred.
But how does that square with the concept of implicit disclosure? Because what you're describing is something that's ambiguous.
I'm describing something from which it's true that there may be different explanations, and to that extent, if one says, well, there could be 2 reasons for a given thing being present in a given document, To that extent, it may be said to be an ambiguous document, but it doesn't follow from that one cannot, that there is no material in that document from which an inference can be drawn. It may be said that the inference in question is an ambiguous inference, and that may be criticisable for one reason or another, but it doesn't mean that there is nothing in the document from which the material can reasonably, upon which that conclusion can reasonably be reached. And we respectfully submit that it is to set the test too high, even if one is approaching the test on the basis of the Warner-Lambert evaluation, that there has to be absolute lack of ambiguity with respect to the relevant document. That's not in our submission either what Warner-Lambert contemplates, or we would respectfully submit what the European case law contemplates. So can I come on to the points made on law more generally? Mr. Turner referred to dasatinib, and my lord has articulated very well the contours of that case and said that it's a similar case. In our respectful submission, it is not. It is a different factual context, and the specification was different. The board in that case, and you can look at it, it's in tab 21. Possibly we don't need to turn it up now, because I'll come back to that in relation to the G221 points. The board, it found in that case that there was no information provided as to which of the structurally different compounds had been tested and in what assay. And my lords, in our respectful submission, what one can't do in this case, which is a strand of my learned friend's argument, is to say, well, because on those particular facts, with that particular specification, there was a finding of insufficiency. That applies equally here. It doesn't. There is a different specification, different material from which a skilled adversary could draw different material. There was no reference by my learned friend to the Ibsen case, to which we referred in our specification, in our skeleton argument. That is also an important aspect of the approach in relation to claims of this kind. And if I could just remind my lords of what was said in Ibsen, which was another Board of Appeal case as to the approach to be adopted. If we set that out in our skeleton argument at paragraph 32, the board, and it's in Joint Authorities 14, which again I would invite my lord's attention to separately to look at the whole decision. But the central point there, the board notes that the EPC requires no experimental proof for patentability and considers that the disclosure of experimental data or results in the application is filed and or post-published evidence is not always required to establish that the claimed subject matter solves the objective technical problem. This is particularly true in the absence of any formulated substantiated doubt, as is the case here. So we respectfully submit that
well, I don't understand how that assists you, because it's not being argued against you that experimental data or results are always required. On the contrary, it is accepted by the respondents that you don't need experimental data, e.g. if there's some a priori reasoning in the specification, structural considerations, things like that.
Right, but what is effectively then being said that in a case of this kind, in a case of what might be called empirical chemistry, well, there's an element of empirical chemistry at least, is that unless you either provide experimental data or you can come up with a effectively solid structure-function relationship,
something,
then you're out, and it's not good enough.
But your problem is you have neither. You ran an argument based on structural analysis before the judge, and it failed. So you have neither experimental data nor structural analysis. So what's left?
We accept that, and that's why I place reliance on the matters that I'll come back to in responding to Mr. Tappin's point. But my point is a more modest one in relation to Ibsen. It's in that we respectfully submit that there isn't any given way under the law of the EPC, or indeed under the law as established by Warner-Lambert, by which a specification is established to be plausible on the assumption that plausibility applies, and that's something that my lords should bear in mind. The particular method or the approach that we invite the court to apply to determining plausibility on the assumption that this test applies is one that is an appropriate one, given the breadth of approach for application of that test. Can I then come to some further observations on that legal standard? We submitted, my lords understand, that Warner-Lambert was articulated only in respect of second medical use patents. Nothing in that case says in terms that the test of plausibility must be applied across the board to new inventive molecules, or what one might call first medical use patents. And the tenor of the decision of Lord Sumption was that it was focused on those patents, and for good reasons. In relation to second medical use patents, a test that would require a prima facie case on the basis of the material contained in the specification, to use Lord Mance's description of how Lord Sumption's test would be taken, has some justification for the reasons given in Lord Sumption's judgment, because of the new efficacy being the only contribution and the only place where invention or contribution can lie. However, one thing we respectfully suggest your lordships should draw from the EPO case law, summarised in G221, is that there is no universally recognised standard of plausibility. That was one of the objects of the reference in G221, to invite the Enlarged Board of Appeal to essentially decide which of the approaches to plausibility should be adopted by boards in future, albeit under Article 56. And that is something that the EVA declined to do. There is nothing in that decision, we've looked at it in considerable detail now, which supports a submission that a higher standard of prima facie plausibility should apply across the board to new chemical entity patents. One can put it in this way. Because there isn't anything that suggests that a plausibility standard should apply across the board at all, it can hardly be said that the EPO was endorsing the application of a prima facie plausibility standard for patents for which the problem, or the particular problem, had not been specifically identified, namely new chemical entity patents. And against that background, we respectfully submit that your lordships may wish to bear in mind that Warner-Lambert was itself a narrow majority decision of the Supreme Court. It rejected a less demanding test for second medical use patents, contrary to the approach that had been taken by the judges below. Obviously, it is a matter by which your lordships are bound, but you are bound in relation to that with respect to its approach for second medical use patents. This court is not bound with respect to its approach in respect of non-second medical use patents. And the very fact that there was a debate as to whether the threshold should be so high in relation even to second medical use patents, where the patentee has not made any other contribution than that which would be established by the plausibility by way of identifying, synthesizing, isolating a new product. One might say, I can use an analogy, a kind of fullest fat version of a plausibility test. We respectfully submit that would be inappropriate to say that more, to use another term used by the EPO, extreme end of plausibility would be appropriate in the context of new chemical entity patents. There's nothing in the EPO case law which we respectfully submit suggests that. Indeed, we submit that the EPO case law is suggesting that the boards should be going down a different path altogether when they're thinking about this issue. Not that their decisions previously were incorrect, which used a plausibility analysis, but one can hardly say that the decision of the Enlarged Board enthusiastically endorses the use of a plausibility analysis, still less a prima facie plausibility analysis across the board for all patents. They could easily have done that. Indeed, they were invited specifically to do that, to endorse one approach or the other, and they declined to do so altogether. And so what we respectfully submit that whether there's real reason to doubt as to whether the more stringent approach is even appropriate in relation to second medical use patents. This court should not be, as it were, setting down as a principle that such an approach should apply across the board to non-second medical use patents. That would be to take, if I may put it in this way, the most extreme approach to the law of plausibility. Because it would be saying, not only are we going to adopt a prima facie plausibility approach, we're also going to adopt that for every kind of patent, even those patents for which the Supreme Court hasn't singled out there being a particular problem with respect to this issue. And we respectfully submit that would be difficult to square with the approach in the EPO in Warner-Lambert. Some reference was made to Idenix, and it is useful just to look at that very briefly, because it said, well, here is an authority, an English court authority in relation to product patents that shows that the approach can apply to product patents. That case was not, in our submission, articulating the precise boundaries of the approach. It's in Joint Authority 2, tab 20. And if you would go to paragraph 114, page 748 of the bundle, what the court was doing in that case was considering the application of agrevo principles. And it said that the same approach should be adopted considering obviousness and whether a technical effect is plausible in the light of a teaching and specification in the common general knowledge. There must be a real reason for supposing the claim convention will indeed have the promised technical effect. But what was the same approach that that court was saying should be adopted? That was the approach of the Court of Appeal in Warner-Lambert. It wasn't the approach of the Supreme Court in Warner-Lambert, because of course this decision was before the Supreme Court in Warner-Lambert. So even insofar as it is said that the courts hitherto have adopted a higher standard of plausibility with respect to product claims, and that has been endorsed, the courts have endorsed the approach of the Supreme Court with respect to those claims. We respectfully say no, they didn't endorse the approach of the Supreme Court with respect to those claims at all. And we would respectfully submit that insofar as this court says, well, plausibility is something that needs to be analysed across the board for claims of all kinds, there is no support in the authorities for saying that the fullest fact version, which requires, as it were, positive proof at the outset, is the one that should be adopted for claims of all kinds. So if I can then finally go back to Warner-Lambert on this point. I drew attention to the dissenting judgment of Lord Mance for two reasons. One, because in our respectful submission, he more fully analyses the effect of the case law, including the Defendant case law, which is referred to in paragraph 194 of that decision, which is a long paragraph analysing the case law that Lord Sumption referred to between 901 and 904. And as I said, we commend that analysis to you. But the point that he was making in 195 was that he thought that a lower standard should be appropriate, and at H, despite the use of phrases such as reasonable prospect and might well abuse, there's a real risk that the test as described by Lord Sumption would amount to will be understood as involving a requirement to establish a prima facie case on the material contained in the specification. In my opinion, the authorities analysed do not put the standard so high. So he was saying that the European case law didn't actually support that approach to placing the standard at that level. And we have seen from G2 2021 that there is a divergence in approach in the European case law. One can't say, on the basis of the body of the European case law taken as a whole, that it says there has to be the higher standard of what might be called prima facie plausibility rather than prima facie implausibility. Indeed, my learned friend says, well, the Enlarged Board of Appeal has endorsed the plausibility analysis. Well, we differ from that, but insofar as they haven't endorsed the fact that a prima facie plausibility test is the right test to be applied across the board. As far as they haven't differed from the technical boards of appeal below, they have inter alia endorsed what might be called a lower standard or no standard of plausibility at all. Because one of the whole points of G2 21 is that it said, well, we're content with the way in which the boards of appeal have hitherto decided these cases, which in some cases have not required any form of plausibility analysis whatsoever. And so we respectfully submit that if my lords are going to lay down guidance in relation to how plausibility ought to be approached, if you accept the argument that that's something that ought to be done in every case, then you ought not to say on the basis of the existing authorities that the approach taken by Lord Sumption and Warner Lambert to second medical use claims applies across the board. Rather, if that is the approach that you take, then the approach of Lord Mance, which he summarised at the end of paragraph at H, that the EPO rejects speculative or wide-ranging unsubstantiated claims, but accept a sufficient tailored claim which appears scientifically possible, even though it cannot be said even to be prima facie established without, for example, testing or assays according to the state of the art. Only if a person skilled in the art would have significant doubts as to the workability of the invention would it in such a case fail for insufficiency of disclosure. We respectfully submit that if that test had been applied in this case, we would have won, and we should have won in this case. And that is not an unreasonable test if one's applying plausibility overall, as the whole body of case law shows, for the approach that should be taken in a case of this kind. If you reject my submission that plausibility is not a general requirement overall for cases of this kind. One might ask, well, stepping back a little bit, what is the policy reason here in applying a particularly high threshold in this case? One can see the rationale in some of the case law, particularly relating to broad claims, that, as remember, was the fons et origo of this whole area. The aim of the jurisprudence is to say, well, look, you can't have a claim to that because you haven't done the work. What you're doing, essentially, is making a claim that has the effect of being able to lay claim to the work done by someone else. Because your claim was speculative, you're entitled then to a monopoly in relation to it, and therefore you're entitled to basically gather in the work that has been done by other people who you can sue on the basis of your speculative claim or your claim that's too broad in a particular way. That's not what's happening in this case. My lords can, of course, criticise the specification and have done in argument, and the judge can criticise the specification. But the fundamental point to bear in mind is that we are seeking to protect a genuine invention that we made, a genuine contribution that we made to the state of the art, used by many people, and we're not seeking to do so in an overbroad way. We are not seeking to claim something that we haven't invented or haven't disclosed. We are seeking, in my respectful submission, to claim
The argument against you is that your clients might have made the invention, but they made it later and not in this document.
Well, in my respectful submission, that's not right. Apixaban was called out for the reasons I'll come on to in answering my learned friend, but the real point is that we did disclose it, we did identify apixaban, not only, but we did disclose it with sufficient specificity and highlighting, and we are not seeking, as against these generics, to claim something that we didn't legitimately invent, in respect of which no contribution or no sufficient contribution had been made at that stage.
Can I just ask a question about paragraph 195 of Warner Lambert?
Yes.
I just want to understand what the test is that Lord Mance is saying should be sufficient. What he says, and I can just read it out, he says about the authorities that he had analysed, that they rejected speculative or wide-ranging unsubstantiated claims, so that's one category, and then he contrasts that with their acceptance as sufficient, a tailored claim which appears scientifically possible, even though it can't be said to be prima facie established without testing several. And then this is the question, the last sentence, only if a person skilled in the art would have significant doubts about the workability of the invention, would it, in such a case, fail for sufficiency of disclosure? So what is such a case?
Such a case in which a tailored claim which appears scientifically
That's what I thought.
possible.
So that's the test.
Well, that would be my submission as to what he meant.
Yeah.
Although I accept that there is potentially a scope question about in such a case.
Well, what that means is another question, but that seems to be what he's saying.
Yes, my lord.
Yeah. Thank you.
So, to summarise on that point, we respectfully submit that if there is a choice that you have to make here, and you are, in a sense, not in the advantageous position of the Enlarged Board of Appeal of being able to refuse to answer the questions that were referred, essentially, at least in the terms that they were referred. That's the approach that we respectfully submit is one that may commend itself to you. Can I then deal with one other point that really my learned friend hasn't, or my learned friends haven't dealt with, which is an important part of our appeal, which relates to the importance of and availability of verification testing. I didn't detect in my learned friend's argument any real dispute about how the principles should apply, that if there was something that provided a sufficient hook, as it were, for the availability of verificatory testing, then the fact that easy testing was available to verify the claims made was a matter that could properly be taken into account and would be supportive of the fact that the specification had actually made the invention. Coming back to my lord's point, which is, of course, a very good point about what might be called claiming too early. so that you say, well, look, you've claimed something at too early a stage, too speculative a stage, in such a way that someone looking at the specification, doing natural things that they would do with the specification, would say, okay, well, I really can't tell on the basis of what's being done without a research program to determine whether or not there is, let's say, efficacy for peripheral neuropathic pain. But it is a touchstone of the fact that we have not claimed too early with respect to apixaban, that all it would take for a skilled person to verify that we had made the invention on the case advanced by my learned friend, namely the case that you've got to have nanomolar potency, was to test apixaban and determine that it had nanomolar potency. Now, in our respectful submission, if there are common general knowledge tests or tests in the patent that don't involve a research program, that enable a skilled person to determine that the patentee was in possession of
Then
that
the
which is
invention
in
is being made by the person who does the test.
The invention is being made by so what is contemplated then, my lord, and if I may say so, that is really quite a
I mean, seriously, let's imagine a hypothetical. The day after this application is published, a third party does the test, and they find, hey presto, it's nanomolar potency, and they publish it to the world. So, who's made the invention?
well, we would respectfully maintain the position that we had made the invention. We had identified that apixaban was out of the massive material, that we had said of it that it was likely to be of value. We had highlighted it in the way that we've been through on a number of occasions.
It's a little bit odd, is it not, to say that the person who hasn't done the test to show that the material has nanomolar potency and is therefore likely to be efficacious has made the invention, whereas the person who did do the test and did find the nanomolar potency has not made the invention.
But that's on the assumption that the person who claimed it in the patent had not done the test and had not discovered nanomolar potency. If the real
they did, then they wouldn't, and it was disclosed in the specification, there wouldn't be anything to argue about.
That tail end of the sentence, if I may respectfully submit, say to my lord, is where the crunch point lies.
Right.
Because if in fact they had made the invention, they had tested it, and they had discovered that it had the relevant potency, which, as we know, they could have done, and there would be no dispute that that's what it would yield. Then in our respectful submission, it is extremely harsh to say you didn't have the invention because you.
But on that hypothesis, the problem is simply the failure of the patentee to put the tests that they actually did into their patent application.
Indeed.
In which case, why should they not suffer the consequences?
Well, my lord may say that's a rather harsh consequence in circumstances in which the patentee has in fact made the invention. And let's test it in the following way. Let's suppose that the only thing that this patent had covered was apixaban, right from the outset. So there was an individuated patent for apixaban. It said this is good for the following reasons. And there was no doubt that you could test it very straightforwardly. On that analysis, notwithstanding the, as it were, unambiguous individuation of the apixaban, the test, my clients wouldn't have a patent for it, because it would be said, well, you didn't put the test result into the patent. It's true that, indeed, the position would be even worse, because it would then be said, well, the person who did the test, let's suppose that Sandoz or Teva did the, whatever it is, the half-hour incubation of apixaban that we had identified, and verified that which we had also verified, namely that it had nanomolar potency. And they put that into a patent of theirs. They said, well, what we've done is we've tested your product for which you've made that claim, using a common general knowledge test, or even worse than that, a test you recommended and suggested that you had done. Who would be entitled to the patent on my lord's hypothetical question to me? Well, it would be Teva and Sandoz. We submit that would be completely unfair. It is us who have done the research program. It is we who have identified the patent. All that the rest of the world needs to do is verify that the claims that have been made in respect of that product are justifiable claims. And that is why we respectfully submit that this is not a situation where you can ignore the purposes for which this aspect of the law was introduced, namely to deal with situations where a patentee simply has not made an invention at all. They've made no contribution to the art. You take the approach of trying to balance the interests of inventors with the interests of the public, which one seeks to do in a number of areas of patent law. In our respectful submission, that's the approach that ought to follow. Can I then finally turn back to some of the points made by Mr. Tappin in relation to the specification, and first of all deal with the point on the arguments that are open, because essentially what is sought to be done is that it is said that we are running and only running an argument on nanomolar potency, and we're not entitled to run that argument on nanomolar potency, and we're not.
I think I didn't understand Mr. Tappin. I may have misunderstood, but I didn't understand him to dispute you're entitled to run the same argument you ran before the judge, which is micromolar potency. He says micromolar potency doesn't get you out, but that's a different point. What he's saying is not open to you is to run an argument of implicit disclosure of nanomolar potency when that argument was not run before the judge, as the judge himself said when refusing permission to appeal on this ground.
Yes. Can I then show you the arguments that we are running and where the nanomolar potency point actually fits in? Because our submission is that this is, in a sense, a tail end of an argument that we are running and are fully entitled to run, namely that the disclosure of the patent overall is sufficient to lead a skilled person, regardless of the precise level of potency that they attribute to being necessary for efficacy, to consider that there is sufficient reason to believe that apixaban is likely to be valuable. And what one could take that from our grounds of appeal. Our grounds of appeal, core bundle, tab 2, paragraphs 12 to 14. Those make the core point consequential upon what we say were the judge's correct findings in the paragraphs that I've drawn my Lord's attention to on paragraphs 165 to 171, that the judge ought to have held that the finding that the patentee thought that apixaban was promising, and the facts identified in paragraph 10 on which that was based, and paragraph 11, those are the points that are referred to above, and which supported that finding, were in.
Well, I'm sorry to interrupt you, but that's not what Mr. Tappin is objecting to. He's not objecting to paragraphs 13 and 14. His objection is to paragraphs 15, 16 and 17. Now, if you're not pursuing them, if you abandon those paragraphs, then the point falls away. But that's what his objection is.
I understand. Let me just show my Lord the points that, as it were, we say we are unquestionably entitled to run, and why the remaining paragraphs, or the remaining parts of the paragraphs, are ones that we also ought properly to be entitled to run as being consequential upon those paragraphs that we are entitled to run. So there's no objection to 13 to 14. We respectfully submit that there should also be no objection to paragraph 15.2, which is a point where we say the judge should have held that the specification would be understood by the skilled literacy as containing an implied assertion to the effect that apixaban was a factor 10A inhibitor with a Ki factor 10A suitable for the therapeutic use.
But that's
it's
putting the same argument a different way, having regard to the judge's finding that the skilled reader of the specification would understand that the criterion of suitability for therapeutic use was nanomolar potency.
Yes.
So although presented as alternative arguments, what's said against you, and I appreciate you may have something different to say, but what's said against you is that these are just the same argument dressed up in different words.
Yes, I understand. Let me come back to that. Paragraph 16, the two statements at 14.1 and 14.2 above, materially equivalent. Those are the points that we rely on, and I've made submissions on in opening the appeal. In reference to the early results and the contents of the specification, were based on actual tests having been carried out, and are not in our submission on the appeal bare assertions, but statements supported by actual, if undisclosed, biological data, and that those statements render it plausible both that apixaban has a factor 10A inhibitor and it's a factor 10A inhibitor suitable for therapeutic use. That's put at a very general level, and in our respectful submission, we're entirely entitled to run that point. Similarly, we respectfully submit that we're entitled to run the point in paragraph 17. The point that is objected to is the specific, what we say, consequence of the judge's finding that the level at which a skilled team would think that plausibility was established was specifically nanomolar potency. And we respectfully submit that that is not an essential part of this appeal, but it is one that we should be entitled to run. It doesn't raise points that are separate factual points. All it raises is the consequence of a factual finding by the judge that was the standard that someone would have been expected to reach. In our submission, this is not a point akin to the first category of points in the Notting Hill case, where you've got an entirely new factual point that's being advanced. All it is saying is, well, all right, if you're saying that that's the standard that should be achieved, our position is in a sense neutral on that. We simply say that there is material in the specification from which a skilled person could reasonably conclude that the invention would be successful. And that is material which itself does not in turns, we wouldn't be here if it in turns gave a particular KI level. So in our respectful submission, this is not a new point in that sense. It is simply a consequence of a point that's already in issue. And we respectfully submit that this is not a point which the judge ought to have rejected. He was exercised, as my lords have seen, by the suggestion that we were specifically shooting for a target of nanomolar potency. We're not shooting for a target of nanomolar potency in this appeal. What we are shooting for is the fact that the specification contains sufficient material to found a claim for plausibility generally.
Before we leave this, I see you're closing that page. Just for my benefit, paragraph 14 of the amended grounds contains 3 subparagraphs.
Yes.
Paragraph 15 contains 2. Paragraph 16 talks about the 2 statements of 14.1 and 14.2 above, suggests they're materially equivalent, and it goes on about 14.1 and 14.2. Is that a typographical error?
I'm being told it is. I'm not quite sure that it is, but I'm being told that it is.
It looks like
that point may fall
I think that each of the references to 14.1 and 14.2 that are contained in paragraphs 16 and 17 should be references to 15.1 and 15.2. Because that's where the
I'm being told by from behind that that's right.
Thank you, because that was confusing me for a bit.
Yes, well, I was as well.
Thank you.
I'm afraid I didn't draft these grounds of appeal.
I think we've probably all read them that way, and it's only recently that I've spotted the typo.
You may well be right. Yes. Anyway, but it doesn't affect the substance of the point. The substance of our point.
I think we've all
is
got
that-
the substance.
I think you've got substance. So that's what we say in relation to that. And then coming back to the points on the patent, we, as I said, make 3 points, and we don't really detect that there was a completely satisfactory answer to them, other than the one that said, well, you could draw different conclusions from the material in the combination of paragraph 170 and example 18 taken together. And as I have submitted, it's not a requirement that there should be only one reason that a skilled person either has or would base their reasoning on to conclude that there is sufficient material in the patent to support a claim of sufficiency. We respectfully submit that the inference that a skilled person would draw on the basis of what it is reasonable to assume happened is a reasonable inference. And if there is a reasonable inference that can be drawn, that is sufficient basis for sufficiency in a case of this kind. We also respectfully submit that the respondents haven't really grappled with the point about verificatory testing in this context, because if there is, let us say, a doubt about whether it is proper to infer that apixaban has been successful, and that's the reason that the quantity has been made, and it is possible to determine whether that is a reason that it's been made, which is a prima facie plausible reason, and it is very easy to test for that. One might say, well, what's wrong with that being sufficient? I said to my lords in opening that the example 18 was not only unusual because of the quantity made, it was also unusual because there was a second crystallization. And my Lord Justice Arnold has said, well, what one doesn't know is whether there were, this doesn't suggest that there was an earlier manufacture of the product. Well, what would one be doing a second crystallization for? To improve yield.
Exactly. That's absolutely routine.
It's routine, but it's the only one of all of the analogues in the specification for which that is done. This is one from which we respectfully submit, in answer to my Lord's speculation as to what one might think about that.
But it's laborious. It's laborious. So a second crystallization has been, since the 19th century, a common general knowledge technique for improving yields of chemical reactions. But it's laborious, and so frequently you don't bother because life's too short.
Yes.
But so what?
But my Lord actually has made precisely the point. It is laborious. It was not done, or at least not disclosed to have been done, with respect to any of the other analogues. What are the reasons why someone might want to increase the yield? Because they want more of the product.
Well, how about because they want to find out what's the best yield they can get? And actually, that's a very common thing in chemistry. Is when you're working up a reaction, first of all, you do the proof of principle experiment. And then at a subsequent stage, you want to find out what's the best yield of this. And it's often at that stage that you do it in larger quantities.
My Lord is, of course, absolutely right. But again, with all respect, that makes the point that I'm making. Why would one do a laborious second crystallization to increase the yield of and only of apixaban, unless there was some reason to think that apixaban was the pharmaceutical in the sense of choice out of the range? My Lord's knowledge of chemistry is obviously far greater than mine, but both of the points that my Lord has put to me are supportive of the inference that could reasonably be drawn, that the patentee themselves had done extra work with respect to apixaban. Why would you do extra work with respect to apixaban. Why would you want to improve the yield specifically of that if you had tested other compounds and found them more satisfactory? It is itself an indicia of effectiveness. It's not an indicia of lack of effectiveness or neutral with respect to effectiveness. It's something that, as a matter of chemistry, is supportive of it. And in all respectful submission, there is nothing to suggest in the specification that there's nothing to the contrary in the specification. And so coming back to the point on easy testing, if it's right to say that there is material from which one can infer that the patentee was particularly interested in this compound, and one could and that they had given reasons why they might be particularly interested in that compound, reasons given at paragraph 170, sorry, page 170. Then, for the fact that it is easily testable, is in our respectful submission something that can properly be taken into account in determining whether or not the patent specification is valid as a whole. The patent was obviously granted by the EPO, wasn't even opposed by the generics. We know that generics are not always shy.
Am I right in understanding from that statement that nobody at all opposed it?
No one opposed it.
Thank you.
And we respectfully submit that in some senses that is an implicit recognition by the whole industry that at least as far as it went, and as my lord has pointed out, with the EPO having sought additional confirmation, that the patent was fine. It's not conclusive in any respect, but it is, in all respectful submission, telling when it is said now that it's a patent that the EPO would regard with suspicion. There's a central part of this patent that is clearly good. So can I finally come to the points made on G221? My lords will have seen that from the reference that essentially the referring tribunal took almost the.
Sorry to interrupt you. Just so as I'm trying to think through what you've just said. So the patent was granted in August 2009. When was regulatory approval granted?
I can't say at the moment.
I'm guessing later than that.
I would guess later than that as well, yes.
I have a dim idea in my mind that there's an SPC on this patent, is that right?
Yes,
so that tells us that it was reasonably later. Yeah, thank you.
But my point is not even quite so much that, it's that, well, it could have been opposed, but no one has really been suggesting that it's, from an EPO perspective, that there's anything wrong with the approach fundamentally. So coming back to the EPO approach, the reference was seeking answers to the question of whether ab initio plausibility or ab initio implausibility should be the test that governs. Indeed, they sought an answer to that quite heavily by reference to the divide articulated in the Supreme Court in Warner-Lambert. That they said that the difference between the two lines of EPO case law referred to cannot be better illustrated than by the judgment of the UK Supreme Court in Warner-Lambert. So they were seeing that, and that you find in paragraph 13.5.5 of the original reference, so T 011618 and 1157 of the bundle. So
I mean,
they were
in simple terms, the majority propounded ab initio plausibility, whereas the minority propounded ab initio implausibility.
Absolutely, and the but it's quite significant that the Technical Board of Appeal saw the Warner-Lambert case as really drawing a dividing line between the strands of case law that had developed at the same time
Sure.
in the EPO.
But the Enlarged Board saw no difference. So what do we make of that?
Well, my lord, one's got to be a little bit careful with the proposition of the Enlarged Board saw no difference. We respectfully submit that what the Enlarged Board actually said was that there wasn't a reason to think that the earlier decisions were incorrect, notwithstanding that they had adopted a different approach. And you find that, albeit not in exactly those terms, at paragraph 72 of the Enlarged Board's decision in their intermediate conclusion, where they say this: applying this understanding to the aforementioned decisions, not in reviewing them, but in an attempt to test the Enlarged Board's understanding, the Enlarged Board is satisfied that the outcome in each particular case would not have been different from the actual finding of the respective Board of Appeal. Now, in my respectful submission, that is not quite saying.
Yeah, but you need to read the next
Oh
sentence
no,
as well.
indeed. but just pausing there for the time being, that is not saying that there is no difference in the approach that's been adopted by the Boards of Appeal. They then go on to say that irrespective of the use of the terminological notion of plausibility, the cited decisions appear to show that the particular Board of Appeal focused on the question whether or not the technical effect relied on by the patent applicant or proprietor was derivable for the person skilled in the art from the technical teaching of the application documents. Now that, of course, is right as far as it goes, but it is not in turn saying we agree or endorse an approach to plausibility on the footing that we do not see a difference between the approaches in question. Indeed, the entire premise of the earlier analysis of the case law was that there was a divide in the case law between ab initio plausibility and implausibility and no plausibility. That was what they were essentially articulating. In this passage, they were saying, well, look, we're going to kind of look beyond that. It's not that they were saying that there was no difference. And as regards sufficiency, sorry, my lord, is.
All right, but I understand that submission up to a point, but what's the bottom line so far as our case is concerned? Because your first submission is no plausibility at all. Understand that. That's a very clear case. Your second submission is that if the plausibility standard is to be applied at all in this context, the correct version of the standard to apply is that articulated by Lord Mance in paragraph 195, which is ab initio implausibility. Now, where do you say that stands in the light of this authority?
Well, it stands in this way. The Enlarged Board is not saying plausibility analysis is impermissible. They would have really said that, I think, if they had thought, if they had thought that the Boards of Appeal had been fundamentally erring and they shouldn't have been doing this at all. But what they are not saying is that plausibility analysis is required in every case, and in particular.
Well, that's your first.
It's my first submission. But my second submission is they're not either endorsing an approach that says that there should be first category of case plausibility analysis in every case either, and in particular not endorsing a proposition that there should be that kind of analysis in a first pharmaceutical product case. Their approach is a different one, which is in the context of inventive step, to look to see whether or not the technical effect relied on by the patent was derivable for the person skilled in the art from the technical teaching of the application documents. And we say that is not really the same as either a prima facie plausibility or prima facie implausibility test. Indeed, one can tell that it isn't, because the Enlarged Board had in front of them the opportunity to endorse one or other of those tests. They didn't do that. They didn't say, okay, well, this is what we're doing, or to say, well, this test that we're applying is the same as one or other of these tests. What they were actually looking at was something quite different. And the reason they were looking at it was because of the purposes of this decision. They were seeking to identify circumstances in which it was appropriate to rely on after-acquired or post-publication evidence. And so that's why the second part of the dispositive of the decision is articulated.
Can I understand a little more clearly what your response is to Mr. Tappan's submission? And let me summarise for you how I understood he put it. And this is a simplification, obviously, for brevity. But he says that what the Enlarged Board has done here is to try to reconcile the two streams of authority by saying, as they do in paragraph 71, that there is a common core between those two, which is to ask what the skilled person, using their common general knowledge, understands that the filing date of the application is being the technical teaching of the claimed invention. And Mr. Tappan makes two submissions. First, he says that's consistent with the majority of Warner-Lambert. He also submits, secondly, that if you apply that test in this case, then the result is to vindicate the judge's assessment. Now,
Well,
what I would be grateful for is your response to those two submissions.
Yes, let me deal with those 2 points. First of all, consistent with the majority in Warner-Lambert. It's consistent with the minority in Warner-Lambert as well. Indeed, my lord might say that it's a consequence of what my lord is saying about the reconciliation of the two approaches, that this approach is consistent even with a no plausibility test, because the Enlarged Board of Appeal wasn't saying, oh, and one thing we can tell you for sure is that the no plausibility cases are ones where which are irreconcilable with this principle. This approach doesn't determine which of those approaches, if one's sticking with the law of plausibility and sticking with those alternatives, is the right one that should apply. But we would respectfully submit that, if anything, on the second part of Mr. Tappin's submission, that this test supports our contentions, because what is said is that the question is whether the technical effect relied on was derivable for the person skilled in the art from the technical teaching of the application. We say, yes, it was. The technical effect was derivable. It was shown in the sense of the particular pharmaceutical was identified. It was identified in the way that we have pointed out, in a way that would, where there were reasons for a skilled person to consider that it was because it was of potential value, and that was easily testable. And so, if one's asking the question, is this a case in which the EPO would have permitted the introduction of post-testing to determine whether or not there was an invention there, we say not only is it a case that would have been permissible under the rubric of the dispositive in this case, that's actually what happened in this case. They did admit after acquired evidence, and that they did so in accordance, we would say, with the principles in this case. They weren't acting wrongly when they granted this patent, and they did so in a way that would have satisfied the requirements of 1 and 2. And putting it in English terms, because there are two ways in which after acquired evidence comes into play. One is actual after post-publication evidence, which is filed in the EPO in order to support a claim, and either admissible or not admissible, in order by these parameters. And secondly, what it is common ground that evidence would in fact show, as here in this case. In fact, one doesn't need to go to that in this case, because we know there was evidence that established that, but it was in fact common ground. So both of those strands of authority we submit are ones that support our proposition in this case. And this case actually suggests that the EPO's approach in granting this patent was correct. That's what it was. There was nothing to criticise in its approach, and where an opposition to it be filed, and this was the basis on which the decision of the EPO to grant the patent was criticised, it would have been rejected, because this is what is contemplated here. The final point on this, last 2 minutes, on insufficiency, on paragraph 77 of the decision, after they go through the insufficiency cases, specifically focusing on second medical uses, and you will find that their obiter discussion is really focusing on that in paragraph 74, although the language in 77 is potentially broader. What's said there, in order to meet the requirement that the disclosure of the invention be sufficiently clear and complete for it to be carried out by the person skilled in the art, proof of a claimed therapeutic effect has to be provided in the application as filed, if, in particular, if, in the absence of experimental data in the application as filed, it would not be credible to the skilled person that the therapeutic effect is achieved. Now, although one can't fit that in absolute terms into the prima facie plausibility, prima facie implausibility point, that is much closer to prima facie implausibility in this context. And that was said even, we would respectfully submit, with the Enlarged Board considering the question of second medical use of patents. So we say that there is nothing in this decision that supports the high approach that has been suggested, that this is, taken as a whole, a decision which is consistent with an approach to first medical use patents being either, insofar as insufficiency applies at all, being the lower hurdle in Lord Max's judgment. And so we respectfully, that's why we submit that this decision taken as a whole is supportive of our position. It supports what the EPO actually did in this case, and it supports what we submit this court should do. Unless I can assist your lordships further, those are our submissions.
No, thank you very much. So,
Can I just-
Mr. Turner, yes, you're entitled to a brief reply
Just
on
5 minutes.
respondent's
That's
notice.
all I need is 5 minutes.
Yeah.
They're just 3 points really. The first, I just need to remind you how the case was. We looked at it earlier. Supplemental Bundle 1, Tab 3. This was the skeleton below. We've looked at it a couple of times. And it's, I drew your attention to paragraph 134. And taking 134 and 140 together, the case being advanced at that stage was that the technical, there was no technical contribution in finding a new chemical compound. Now, my learned friend then took you to the fact that classical obviousness wasn't challenged. That is correct. Why wasn't it challenged? Because in order to succeed on classical obviousness, we had to show not only was the structure obvious, but we had to show that the effectiveness as a factor 10A inhibitor was obvious. That's why there was no case of classical obviousness. And the case that is being run here is not a case of classical obviousness, it's a case of agrevo obviousness. And I addressed you on that. And we say there's simply no good point there. The second point is Lord Justice Jacob in Lundbeck. And that's at tab 10 of the joint authorities. And this was a point that, and of course these statements were made in the context of this case, and they're quite correct, that where the inventive step was a particular synthetic method, a product per se claim gave more than that synthetic method, and that's what Lord Justice Jacob is dealing with in paragraphs 54 and 55. But again, it can be tested, asking if the escitalopram was used for other purposes. Yes, it was extending beyond the teaching of the patent, but it was still using the technical contribution, because the technical contribution gave you the molecule. And what Lord Justice Jacob was not considering in this case, in that case, was circumstances where the claim exceeds the technical contribution in the sense that the patent would not be making use of the technical contribution, the patent claim. Finally, I wanted to just mention, we don't understand, we're only given it this morning, T424 of 21, we don't understand its relevance. It's not in the case law book, it's a no distribution case, and it was concerned, if one looks at the claims, with claims to antibodies per se. There were particular antibodies that had certain amino acid substitutions at certain places. One could see that from the summary and facts of submissions, page 1. And there were also use claims. And the question, as I understand it, having studied this for a short period, and the question, as I understand it, was whether, for the purposes of sufficiency, how broad should those use claims, or how narrow should those use claims be? And that was being discussed in that case. But there was no suggestion the product per se was not inventive. It certainly was in that case, so it's of no relevance in our submission. Might also just finally, IPSEN Ipsen, which is at, my learned friend mentioned, I think we haven't mentioned it in the opening, but if I can just give you a reference to it, I don't think we need to turn it up. The authorities at tab 14, my learned friend sort of picked that as his favourite implausibility case, but if there was a theoretical basis for the claims being made, for the activity being made in that case, and one can see that from paragraph 11, so there was some a priori reasoning which we say is permissible. My lords, I hope that was no more than 5 minutes.
Very good. Thank you all for your hard work and submissions. This interesting case, which we will obviously need to think about, and we will do so. We will produce our judgments when available in draft in the usual way for you to correct typographical errors and other obvious misunderstandings, but not to re-argue the case. And as I'm sure everybody in court now knows, that will go out to those on the circulation list that's been provided under embargo, and the embargo is to be strictly observed. The other purpose of that exercise is hopefully to enable you to agree an order consequential upon the court's judgment. If you are able to do that, well and good. If you can't, please file brief written submissions, and we will decide what consequential order should be made on paper. Thank you again.
All right.